How far along are you?
5 minutes.
She's consuming alcohol while she's while pregnant.
How?
You're 5 months pregnant. You have positive alcohol usage on August 3rd.
No.
Am I reading Mandarin? I mean.
That's
Right?
according to the device.
The device says that you're drinking.
That was hand sanitizer at my job, which I emailed my probation officer that day. It's not alcohol. That's why they took me out the register and put me on the floor to where I won't be around anything that consume alcohol, which is the hand sanitizer at my job.
The judge has the data. The defendant has an explanation. In this courtroom, only one of those matters.
And I let my probation officer know.
Sanitizer dissipates in a matter of a second. Once you put it on and you're done like this, it dissipates in a matter of seconds.
But they write down all the registers and stuff. I have not consumed any alcohol at all.
That's not what this report says. Not only does this report say that you're consuming alcohol, you have excessive skips while you're on probation as well. Your
Honor,
hold on a second. Hold on. Okay, so April 4th, skip test. April 16th, skip test. April 18th, skip test. April 24th, skip test. April 25th, skip test. April 29th, May 2nd, May 15th, May 19th, May 22nd, June 2nd, June 4th, June 8th, June 9th, June 13th, June 16th, June 23rd, June 25th, June 26th, June 30th, July 2nd, 5th, 11th, 12th, 13th, 15th, 16th, 18th, and it goes on and it goes on as the day is long.
I was here on the 11th. I seen you on the 11th. We had court. And I said, I work at the register, and I explained to my manager that I had to step away from the register to blow into my device. So as soon as they understood that I'm on a case to where I had to step away from the register, then they had allowed to me because I have 3 hours of window to blow into my device. So I had got that handled, which I told my probation officer as well. So I allowed my manager to understand to where I could keep my job, to where she can move me to a different department, to where I won't keep leaving from the register to go blow into my device, so I will not be late.
Not only are you allegedly skipping, not only are you allegedly consuming alcohol, but you also have a prior DWI, felony DWI with a child from a year and a half ago.
Drug test, and I passed all my drug tests, so I'm just impossible because I have, and you can go to, and they took my blood test and my doctors as well too. So I have not consumed any alcohol during my pregnancy or before my pregnancy. And when I stood before you on July 11th, I have not took any alcohol at all. That's the honest truth. And I saw you on the July 11th. And then after that, when I had found out I was pregnant, they took my blood and everything. I have not consumed any liquid of alcohol down my throat.
We have clinicians that evaluate you to determine what the best course of action going forward on this probation is. They've deemed, after doing all their research, that the best way moving forward is to put you into a residential treatment program. I like to follow the advice of the clinicians because they know what they're talking about. Not only, are they saying this, but you're also providing us with evidence as to why it's a good idea. You're saying you're not consuming, but I have concrete evidence that you are, and I have dozens of skip tests when you're not supposed to be skipping.
What
I know.
They said I consume alcohol because that's the day that I emailed my lawyer that day, and I was at work.
It's not a negotiation. That's what they're recommending, and I think that it's a good idea.
So that means I go 45 days, I lose my job, I lose my apartment, I lose my kids, might end up having a miscarriage because I'm in there for 45 days for something that I did not do. That's the reason why I'm back, because I have not.
So just the only other thing I could offer is maybe Santa Maria. Have the clinicians considered that? Did they know she was pregnant?
My recommendation was a community residential program followed by self-support. So,
They didn't recommend Santa Maria. Did they know she was pregnant?
What's the difference of Santa Maria
It's
versus?
an outpatient drug residential facility treatment center for pregnant females. It's only pregnant females. She can get a bed there reserved for her, but they have to accept her into the program. It's common in felony with pregnant women, but I don't know what it's like here in misdemeanor if they even offer the Santa Maria Hospital. But it's supposed to help pregnant women.
Are you married?
Yeah.
Who's taking care of the other kids?
Me,
You don't have any other person in your life?
boyfriend, but I mean,
Okay, so you currently live with your boyfriend?
Mhm.
So he's got, possession of the apartment, I would imagine as well. So you're not going to lose your apartment,
home is in my name, not his.
okay? I mean, as long as the rent is being paid, but my concern is that you're not consuming alcohol, especially while pregnant, because if you do, you're ensuring a lifelong potential problem with that child. I have evidence here that you're consuming alcohol. I have evidence here that you're refusing to blow into the machine like you're supposed to. And that's why we do these.
But
Recommend.
I'm so
I
sorry.
know that you don't like it, but I'm
No,
sorry.
because I can't just stand here and just, I can understand the skill part, but the actually consuming, drinking alcohol, I can't stand here. And that's on everything I love. I have not consumed any alcohol since you put me on probation. Since we had this last conversation, I have not put a
Have
risk.
evidentiary proof to the otherwise.
Germans have alcohol in there. So it's like y'all saying that I actually took a cup. I actually put it to my mouth and I actually drunk the alcohol while I'm pregnant. I can't stand here and let that go by and feel like that's okay. Because I knew I have not. And I emailed my probation officer when it happened, when it violated on my device. I'm just national guy. I'm sorry. I'm just trying to get him to understand.
I understand that you're upset.
I literally emailed her when the device was violated. When it said violation, I was at work on lunch trying to catch it before 8 o'clock. And that's when it said violation. So I'm trying to figure out, we have hand sanitizer everywhere on the registers. So that's where it came from. It have not come from no alcohol.
It's not hand sanitizer. Hand sanitizer doesn't go into the actual tube that you blow into. I mean,
Your
I'm
Honor.
sorry if you,
Your Honor, would you consider if she meets the requirements for this Santa Maria
of
outpatient,
course.
would you be?
Oh, outpatient?
Yes, Your Honor. In light of the fact, like,
She's been on probation. We've given her the opportunity to do it on her own. And you're not doing it. So that's why we have this now as the alternative. And I always tell everybody, look, I will give you the opportunity to try it yourself. If you're unable to do it, then we're going to do it my way. And I know that you're not going to like it, but that's the reality. The reality is that we don't want you to consume alcohol, especially while you're pregnant. And I've got evidence to the otherwise. And so the only way is to do it our way. I know you don't like it, and I'm sorry, but that's the reality.
Your Honor, if I may, can I have the date that you say that she tested positive for?
Here, I'll give everything to you. If you want more time to take a look at it, just you guys hang tight, go take a look, and we can come back in up here and talk. Don't leave. Otherwise, I'm going to issue a warrant.
Yes, sir.
Last name again, James?
Richardson, Judge? Take a step.
Mr. Richardson? How's jail? Wonderful.
Missing bills, I'm missing life, I'm missing everything, missing my job, work opportunities.
And one of the things, Mr. Richardson, you need to consider that when you're out there in the free world, when you're picking up cases, one of the first things that you should think about, even before you do anything, if I get picked up, if I go to jail, do I have anyone that's going to bond me out? Because when you don't, you wear orange for a very long time. You were on bond for 2 serious assault cases, and now you picked up a 3rd case. This is what happens. Your lawyer's asking me to give you another PR bond. Now, it scares me. What are you going to do if we let you out?
I'm working with law enforcement to figure out exactly where the,
Don't talk about the facts of the case.
I have no interest in talking about the facts of the case. My concern is if we let you out, are you up to no good? That's my concern. We gave you the opportunity and now here we are again. So
I'll be doing good. I'll be doing good. They let me out, I'll be doing good. And I have,
Judge, he has a job lined up with the Port of Houston. He just wants to start working.
having your life now, Mr. Richardson.
my grandma, my sister,
Your daughter.
my daughter.
Where's mom and dad?
My mom's in Dallas and my dad lives in Richmond.
Do you have no interest in getting in contact with either of them?
Yes, I do. But I work. I have paying jobs, good paying jobs. And I don't think my dad has a job. Or he is a
Say hi.
cop, something like that.
I don't know where he would go if we let him out, but I'm not letting you out on the street. So we need to figure out where you're going to go. I'm going to tell you now, I'm going to be very hard pressed to just give you another PR bond.
He would say he would live with his grandmother.
Where were you living before?
I was living with her, but I spent time at my friend's house.
Okay.
That's not going to happen. I'm not doing this now. It's not gonna happen. We need to figure out a place that you can go to, that you've got a permanent home to go to, whether it's going to be grandma, mom, or dad. But friend's house, it's not going to work. And then I'm going to tell you, if I do let you out, you're going to have a whole host of monitors so I know where you are at all times. You've now picked up your third case. I'm going to do everything that I can to prevent you from picking up a fourth. Do you understand, Mr. Richardson?
Sir?
Okay, so, start talking around with family members, see who's going to, who's
Going
able
to
to take.
reduce his bonds at all, Judge?
Of course.
Can we reduce them to 2,500 each at least? I don't know if he'll be able to make that. So it'd be 25. Okay, thank you,
But
Judge.
I'm going to tell you now, I'm not letting you out on the street to just roam it because nothing good happens on the street in the middle of the night and you just roaming it. So if you want to get out, you got to find a good place to stay. Grandma, mom, dad, somewhere where it's reliable, that you got a bed and not just a friend. Do you understand, Mr. Richardson?
I would say a friend, but it was more of a partnership, business partnership. But they didn't hold up on their end at all. So we can, when my grandma could give me a PR bomb because where I work.
I'll let you guys figure it out. I got to handle a bunch of stuff.
Thank you,
Let me
Judge.
know.
Judge, we have an arrangement.
Let me talk to Carl first. Good morning, Miss Lathan. Thank you, Mom, for coming. Appreciate it. Miss Lathan, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. Okay.
Yes, Judge. The complainant reported being assaulted by the defendant, who is the complainant's daughter-in-law, at the defendant's residence in Harris County, Texas. The complainant stated she was at the residence with the defendant for the complainant's son's birthday. The complainant advised she engaged in a verbal altercation with the defendant about the child not saying goodbye. The defendant got into the victim's face and the defendant lunged at the complainant as if the defendant was going to strike her. The complainant stated her son and husband attempted to separate the defendant and the complainant, but the defendant was able to kick the complainant's right breast, causing a high level of pain due to recent breast cancer surgery. The complainant stated the defendant yelled, quote, "I will fuck you up," as she was pulled away. The defendant stated they had a get together for the defendant's husband. The complainant became upset during that conversation, and the complainant was slamming doors, yelling and getting in the complainant's face, but did not kick the complainant as she was 9 months pregnant. The defendant was identified with a Texas driver's license.
Make your statement, Judge.
course.
And so this case was it 6 months later that it was filed? They never spoke to any of the witness. Janitha was present at that time. Terrell, who's a bailiff upstairs, was present at that time, which is Jillian's husband. He didn't want to go through the whole IED deal and give a statement just yet. But I did provide a witness statement from Janitha where she was there. She was 9 months pregnant at the time, Judge. She had her baby a week later. Her mother-in-law did have breast surgery, cancer surgery before on her breast, but she couldn't lift her leg up 3 inches, much less high enough to kick her in the breast. Police officer had none of the information with regards to Janitha being present. Janitha was there. There was the mother and the Terrell and the father holding the two back, I guess, from each other like this. It was split up, and then that was it. 6 months later, charges were filed against Miss Layton, and that's it. Officers never spoke with anyone, didn't get the other side of the statement. Janitha did provide a witness statement. The court can ask Janitha. We're open to the court asking the questions to Ms. Kimbrough. She didn't witness anything after it was split up. They went home, I guess, Janitha, and then that was it. There was no physical contact, anything of that nature. Nothing.
Give a response, Mike.
Judge, I haven't read the offense report thus far. I know that this is what the victim has reported. I don't know who the investigator spoke to, but I know this was a delayed report. That's why the 2B warrant was filed.
There was no documented injuries, Judge, no photographs, no nothing. They just on their own volition.
Remember, this is just mere probable cause, right? So, and the fact that, she's pregnant is unable to, I don't know that, right? So all this is a probable cause. It doesn't mean that you're guilty, right? Just it's a mere probable cause. There's still a lot before someone can be found guilty beyond a reasonable doubt. I mean, that's a lot higher standard than what we're just doing today. I am going to find that there's probable cause to go forward. What's the dynamic now? I guess it's 6 months down the road.
I mean,
do they want to have contact?
Do you still have contact with your mother-in-law?
So on Marilyn, is there still contact between you guys?
On and off, not too much.
Okay, so the only thing I'm going to ask is just don't have any threatening or harassing contact with this person. That's all I'm going to ask you to do at this point, okay? I'm not going to put any other conditions in your bond. Just be careful. Don't pick up any new cases. You got a great lawyer. I will waive your appearance. You don't have to waste your time coming to court. Mr. Kamek will tell you when you have to come back to court, and that's all there is to it. Just be nice. Don't pick up any new cases, You guys have any questions?
That's it.
So for now, what I'm going to do is I'm going to have just Michael create the bond conditions. We'll have you sign it, and then you guys are free to go. Just do your thing and just have fun.
Judge, did you set a bond amount?
Oh, Mr. Torres, you're charged with assault of a family member. You are facing a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On October 15th, 2024, officers dispatched a welfare check at a residence in Harris County, Texas. Officers made contact with the complainant, who was observed to have a fresh, large bump to the back of her head. The complainant was observed to be very scared to speak to law enforcement at the time of their arrival, while the defendant was in the area. The complainant insisted that she wanted to leave the house and get out. The officers made contact with the defendant, who stated that him and the complainant had been dating for about 1 month and had recently had a couple verbal arguments. The defendant stated that he was outside and heard screams coming from inside. And when he came inside, he found the complainant on the floor in the living room and that she had fell from the stepping stool that was in the living room. The defendant stated that the argument never got physical between them, and the officer contacted the witness, who called in the welfare check and stated that he received a message from the complainant of a picture of a firearm. The witness stated that the complainant began sending him audio through WhatsApp, and on the audio, you can hear the complainant say, "Jose, run. He is going over there with a firearm. Run now." The second audio that was sent from the witness, you could hear the complainant telling him, "I was able to take the firearm away from him, but he had a knife. Run." The witness stated he called the complainant and was able to hear a disturbance between the complainant and a male. The complainant tells the witness, "I don't want to die," and the witness then overhears a male yell, "If you call the police, it will get worse." And then that's when the witness he heard them arguing, and he can tell the defendant's mouth was then covered and can no longer talk. And then the complainant stated the defendant was upset that her ex-boyfriend was trying to pick her up, so the defendant placed a firearm inside his waist and said he was going to look for her ex-boyfriend, and he left the house. The complainant stated the defendant returned a short period later and continued to argue with her about leaving the house. And when the complainant was exiting the master bedroom and going towards the living room to leave, the defendant pushed her back, causing the complainant to fall to the ground and hitting her head with the floor. The complainant stated she lost consciousness after she fell, but when she woke back up, she was already laying on the bed when the defendant was there pleading that he was sorry and he didn't mean to hurt her. The complainant stated she did feel pain. And that's it, Your Honor.
So it is the pushing and falling on the floor and getting hurt that way. Okay. Mr. Torres, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? You don't understand?
No, not one time.
He said, no, he's not gonna have contact.
Okay. I'm also ordering you not to be in possession of any weapons. No guns. Do you understand?
Yes, sir.
If I find that you have a weapon, if I find that you try to have contact with this person, I'm going to put you in jail and you will not get any more PR bonds. Tell me, are you a United States citizen?
Yes, sir.
You are? I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Yolis Hernandez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? If you violate this court order, the state can and will file an additional charge against you, a violation of a protective order, and then it's really bad. Do you understand?
Yes, sir.
If you ever have any questions, Mark can help you and guide you through this. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Mr. Metzen. He will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. So don't pick up any new cases, no contact and no weapons. That's it. Do you have any questions? Okay. As far as the bond is concerned, we need to take care of that.
Yes.
Do you have any prior criminal history that you guys see? Alex?
I can run his NCIC.
In Texas, no, Your Honor, I don't know. Outside, I doubt anything outside.
Your Honor, I don't see any other criminal history.
Okay. Mr. Torres, I'll set your bond at $500 and I will give you a PR bond today. Okay, but I will not give you another PR bond. If you pick up a new case or violate these conditions, I'm going to take that PR bond in a moment's notice. You understand? Okay, my friend. So take a seat. We'll have you sign all the documents, but don't leave until we let you go. Okay? All right. Okay. You want to do the other gentleman?
Yeah, let's do that.
Is this,
Mr. McDonald, Jonathan McDonald.
all right. So Mr. McDonald, your lawyer wants me to set you a bond. I don't know anything about you. I've never met you before. I know you're going to tell me it's little bunnies jumping in the woods, but my main concern are two things. Are you a danger to the community? Number one, if you're not, and my other one is, are you going to go back to the jurisdiction you're wanted from? My other main concern is what you're wanted for, because I don't know. So Amy, tell us about Mr. McDonald.
Yes, Judge Patrick. So he's wanted from Faulkner County, Arkansas for a theft by receiving $1,000 to $5,000. It's a felony. You looked at his criminal history and would be opposed to a bond at this time. He had concerns about the danger of the community. In particular, he had in 2024 an arrest that resulted in 7 open charges.
So he had 7 open charges did you say last year?
This year, 2024.
Oh,
Yeah. Felony possession of a firearm by certain persons, driving with license suspended, failure to pay license fee, theft by receiving, which is separate from this one. And then a fake license plate, possession of a controlled substance, and possession of drug paraphernalia. He's also had in 2021 forgery, dismiss, felony property dismiss, felony domestic battery 18. He's had a federal firearm charge from 98, federal assault on a postal employee from 99 that ended their probation. And he's had 2 guilty convictions for theft of property and burglary in 88. So at the time, we should be asking for no bond for those reasons.
Is he on probation or parole right now? Do you know?
Not that I know of. Dave's gonna come up in a second to tell you for sure, but I don't see that he's on it now.
What's your position?
Judge, we're asking for a bond because it looks like the Faulkner County, Arkansas case is theft by receiving. It's not violent. Additionally, it was a warrant, so there's no failure to appear or any issues like that. I did.
His 8th charge this year, right?
I wasn't aware of that.
Can I speak?
Yes.
Sure.
Okay, she asked me about being arrested.
Let's not talk about the case.
Oh, okay.
We're talking about my case. My only
Okay.
concern is, I mean, you've got 8 cases this year.
8 cases this year.
May I, to the judge? Okay, Judge. I flew into Arkansas. My mom was dying.
Whoa, let's not talk about
Well,
that.
I have to give him some background so you can see what happened. I borrowed my ex's vehicle.
No, let's not just talk about that. Let's just not talk about that.
Okay, well, let me get to it. That's been just, I don't know why that ain't showing up. That's been dismissed. The only thing I've been charged with, the only thing I've agreed to is paraphernalia and her vehicle, not mine, her vehicle. But she's saying, everything.
Is it dismissed? Or out of the 7 charges, what happened?
I'm saying that they're arrested.
It was
Dave
dismissed.
said that they're open charges.
It was dismissed.
Still open.
That's what Dave said. But I am saying that he was arrested for them.
They're all still open.
The prosecutor dismissed all that gun stuff and all that. My lawyer just contacted me last week. The date where everything was supposed to have been done, they changed it to January 25th. I'm pleading out to the insurance and stuff on the vehicle. It wasn't my vehicle, but I'm pleading out to it because I was driving it. And paraphernalia.
Okay, so in
That's
January
it.
you'll be pleading.
To paraphernalia. Yeah,
So
misdemeanor.
all 7 cases are still.
Everything gone. Only thing is,
My concern is that when you have all those open cases, it makes you more of a flight risk.
I've never fled from anything. In fact, Your Honor,
But you're here.
listen, I didn't flee. I never had.
I think it was, they filed a new case.
They
He's saying
filed, I
that
was
it
home.
wasn't, he did not flee. It was a warrant.
Is it to be?
Yes, that's what my client stated.
But what I will tell you, Your Honor, the conviction she meant in 1999, granted, yes, I did go into federal custody. The judge gave me a self-surrender. They sent me a letter saying, be here at this time and this date. I was there. I got there June 14th, 2 o'clock,
You don't mess with
1999.
the feds.
I didn't come out till 2004. But what I'm trying to tell you is I got sent a letter to come to prison knowing I wouldn't get out for 5 years. I was there. I never ran from anything. I'm not dangerous. I've never not answered anything. Nothing. You will never find that. I've never escaped anything. In fact, if I just be honest with you, Your Honor, I don't even really know if you give me a bond, make it. So I'm like, I told her, you know what? I just do the 14 days
So
or
you don't
whatever.
want a bond?
Well, I want one, but at the same time,
Okay, let's
if it's gonna be a
Can I
big
just
bond.
speak for him? Thank you so
I'm
much. I
sorry.
appreciate that. Mr. McDonald also has a couple other background facts that I wanted to make you aware of, Judge. Number 1, he does have health issues when he was arrested October 26th. 2 days ago, they took him to Ben Taub. He has a prior heart attack and stents. He says he did get his insulin shot, but he's got some diabetes and high blood pressure issues. So that's just another aspect to consider.
You know, Mr. McDonald, you got to understand this life is so precious. And when you have multiple heart attacks and you're using that kind of dope, you're begging.
Oh,
If you're using any kind of dope,
I've never used drugs.
if you do, you're begging for trouble. So I'm just saying, be careful when you're out there, especially if you have all those health issues. If I were to set you a bond, it would probably be somewhere in the neighborhood of around 5,000 to 10,000. So
No.
that's what it would normally be with these types of fugitive cases, just so you know.
Okay, Judge, I think we'll keep our waiver.
Okay. Hi, Jay.
Days right now.
Happy Monday, man.
How are you?
Tell me about, this is Mr. Tapia?
Tapia, Johnny.
So just with the, at very little notice, but He's wanted out of New Mexico for 2 counts of aggravated battery of a household member by impeding, interfering communication, and tampering with evidence. Due to the severity of the charges and the amount of charges, is that we would be opposed to a bond. I was also seeing that he was part of a protective order back in October of this year, and it's still current. It's the temporary protective order that's still active for another month, with I'm presuming the one for the impeding as a protected party.
So he has 2 open aggravated assault cases by strangulation?
Strangulation or suffocation, interference with communications, battery on a household member, tampering with evidence, with, it says in parentheses, so I'm not really sure how it's, but it says in this verbatim, highest crime, a capital first or second degree felony. And they want no bond in New Mexico.
Yeah, I'm sorry. It's a little bit too much baggage for me, Mr. Tapia. You know, with all those charges, it makes you just too much of a flight risk for me. And it's just too much. It's just too dangerous. I'm sorry.
Even if I were to buy a plane ticket the next day, Your Honor?
Can't take a plane. You've got a warrant for your arrest. You get on a plane, they're going to arrest you the minute you try to get on. You can't take a plane. You got to find another way. My concern is that if we let you out, you're not going to go back. You'll take flight. And that's the main concern. Has he waived yet?
Not yet, Judge.
So the way it works now is if you waive extradition, we give that jurisdiction 14 days to come get you. And if they fail to come get you within that time, then we release you, or Harris County releases you.
So on the 15th day, I would be released.
Again, we talked about that, but again, the law says up to 30 days. Most likely it's 14 days, but except for extenuating circumstances, which we
The law
discussed.
says 30, but we have so many people in Harris County and so many people in jail. As a courtesy, we do 14 days, right? Sometimes, every so often, they'll ask for an extension. I may grant it, I may not. It depends on how much they want, you know. But typically, by and large, it's 14 days. And if they don't come within that time, they file a dismissal and they release you. But you got to understand, even if that happens, the warrant is always there and it will always remain there until you go back and take care of it.
Yes, sir. That's what I want to do is just take care of it. So
well, we'll get you there for free here soon.
And is it up to you guys or is it up to Albuquerque to?
It's up to them to actually come and get you. So we reach out to them and let them know, hey, we've got Mr. Tapia here. Can you come get him? And then depending on how many people, like, is it Albert? You said Albuquerque?
It's New Mexico. It's Albuquerque.
From New Mexico, you know, they may want to try to get everybody at the same time. So that's where they try to arrange it all at one time. They don't want to come back and forth because it's thousands of dollars that they're spending just to come get you. You know, it's expensive. It's not cheap. And I'll tell you this too, guys, you know, when you pick up multiple fugitive cases, depending on where jurisdiction you're from, they may try to recover that money from you. So you got to be careful. You don't keep picking these cases up because they're going to charge you.
I didn't even know I had a warrant out. That's so.
Well, be careful, you know.
Yes, sir.
Yeah. Okay, guys. What did you want to waive formal extradition?
I believe that's what I said, right? I waived it.
The 14 days?
Yes, the 14 days.
Is that what you want to do?
Yes, yes.
Okay, guys. We wish you the best of luck. Okay.
Thank you, Judge.
All right, gentlemen, you're going to go right back to that work for me. I'll be grabbing this.
Mayor, put cases down in the docket, Judge.
Good morning, Mr. Sanchez Vasquez. Mr. Sanchez Vasquez, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 100 days in jail. Credit for the 50 days that you've done. Is there an accident in this case, man?
I think
Alex?
No, Your Honor, let me pull up the case.
I think he was just found in the driver's seat.
There's no accident, Your Honor.
Okay, great. Wonderful. I want to make a couple things clear to you that from now on, you are not my problem. This is now a second DWI. when you pick up a third DWI, now they will charge you with a felony offense. Instead of days, you are now facing years. And you'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison for the rest of your life. If you were ever pulled over in a car, even the most remote smell of alcohol, you could be in prison for a very long time. What I'm trying to tell you is that if you even have a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses, test on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this. Now, is it true or untrue that you had a 0.15 or above?
Yes.
Is it true or untrue that you had a prior DWI with us?
Yes, sir.
Is it also true that you had an open container in the car?
Yes, sir.
True to all the enhancements. How do you plead to the offense, guilty or not guilty?
Guilty.
I will find you guilty, sentence you to 180 days.
100.
What did I say?
180.
Oh, sorry, 100 days in jail, 50 days credit, true to all enhancements. I'm going to suspend your license for 2 years. Is there an immigration detainer on this gentleman?
Yes, sir.
You now will be shipped off to immigration. The only other thing I'm going to tell you is that if you come back to this country, do it the right way. Ask for permission first, because if you get busted by the feds, you could be looking at serious time in federal prison. Do you understand?
Yes, sir.
All right.
Probation isn't flexible, it's precise. Miss one step and the system steps in. In court, compliance is the only defense.